Hello, and welcome to this presentation on U.S. visa options for international tech professionals, entrepreneurs, and investors. This presentation is designed to go for an hour and a half. The presentation piece of this will be about an hour, and then I will take questions after that and answer them in the order they come in, and I will do that for up to a half hour after the presentation ends. So if you have questions as we go along, I encourage you to put those in the chat. And like I said, once I get through the presentation part of this, I will get to your questions. This presentation is being recorded, and we will make the recording available to you, to all attendees of this presentation. We will also make the slides available. Here on this first page, if you would like to follow my law firm, Graham Adair, you can scan this QR code and follow us on LinkedIn. We provide new content very regularly, news alerts and updates. We provide videos and tutorials. So feel free to follow us to stay engaged. I would encourage you to do that. And with that, let's go ahead and jump into the presentation part of this. Just to quickly introduce myself, my name is Chad Graham. Like I said, I'm from the law firm of Graham Adair. I started my law firm with my business partner, Sam Adair, about 14 years ago. Prior to that, I was with a large immigration practice group, and I work with exclusively in the employment-based immigration sector. And I've been doing that for, it says 16 years here, it's actually 17 years. I've been doing this. I work with individuals and corporations across a broad range of industries and companies of different sizes, from the startup phase all the way up through publicly traded companies. I work at the operations level of my law firm, helping with setting goals, overall firm direction, strategy, and compliance issues, as well as technology. This is where I brag just a little bit about the law firm, so I won't spend too long on this slide. But the reason I show you this is because our firm is very focused on the customer experience and making sure that everybody has a really good experience. We have some very specific ways we do that. One of the most important is communication and being able to get a hold of your attorney or your paralegal at any given time to know what's going on with your case, and also to make sure that your case receives a successful outcome. This here is the agenda of what we will go through on this call, or on this presentation, I should say. So the presentation is divided up into two sides. One is the non-immigrant visa options, and the other side is the immigrant visa options. What that means, generally speaking, is when somebody comes to the United States to work, typically they come here on a work permit, which is considered a non-immigrant intent, meaning the intention is that you're going to come to the United States for a specified period of time to do work and then return to your home country. Now, obviously, people who come here don't always want to go back to their home country. Sometimes they want to stay in the United States. In fact, I would say most of the time people want to stay in the United States on a long-term basis. Therefore, there is the immigrant visa path in order for somebody to apply for a green card. So a lot of times we call it a green card, but what we're really saying is that they're applying for lawful permanent residency through an immigrant visa option in the United States. So this is kind of the agenda that we'll go through here, starting with the non-immigrant visa options. As I said, most of the time when somebody comes to the United States to work, they come here with a work permit. Typically, these are sponsored by a company. So I'm not saying it's not possible to come here without work sponsorship in the employment-based arena, but typically when people come here to work, they have an offer from a U.S. company that sponsors their work permit. The first work visa I want to talk about here is the H-1B. This is the main work visa that you'll hear about. A lot of times when this topic comes up on the news or somebody's talking about employment-based immigration, they refer to the H-1B. This is sort of the most common type of visa. So if you have a small company and you're looking to hire someone who needs a work permit, often this is the work visa that you would go to is the H-1B. And in fact, a lot of times when you find somebody who needs work authorization, they may already have an H-1B with another company, and then you can look to transfer that H-1B to your company. Or if you have an H-1B, then you could transfer your H-1B to a new company. So H-1B is a specialty occupation visa. The easiest way to think about this is it's the positions that require professional level positions that require at least a bachelor's degree or a bachelor's degree equivalency. A lot of times these positions are called white collar types of jobs. It's a pretty open category. As we'll talk about later, there's some other categories that are a lot more narrow. The H-1B is fairly open in terms of which types of professions qualify potentially for an H-1B. H-1Bs are subject to an annual limit of 85,000 new H-1Bs every year. Now, if you have an H-1B, or if you're at a company and you want to hire somebody who already has an H-1B, then you don't need to go through the lottery system again and do this selection process. But if you're somebody who is here, let's say, as an F1 student, and you're looking to change from your F1 student visa to an H-1B, that's when you would need to go through this lottery system. So the way this works is the 85,000 new H-1Bs are made available every year. You can apply for those up to 6 months in advance. So the government's fiscal year always starts on October 1st. So you can apply starting on April 1st. But the U.S. Citizenship and Immigration Service, or USCIS, has developed an electronic registration system. And now they actually run that registration, or they run the lottery through that electronic registration system in March. So typically, if you're looking to get an H-1B, my advice is to start thinking about that at the end of the year, like in December, or definitely by January, because you need to be sure that your information is put into the electronic registration system so that when the lottery is run in March, you have a chance of being selected. So the nice thing about the electronic registration system is that in prior years, you actually had to prepare the whole petition and file it with the government in order to be included in the lottery. And so we typically saw about 100, I would say between 150 and 200,000 applications a year. Those numbers are always fluctuating, and actually they're always kind of increasing. And so that's why there's a lottery. If there were fewer than 85,000, then everybody would be selected and everybody would get an H-1B. But because the demand is higher than that 85,000, they do a lottery to make it fair to everybody who applies. So now with the electronic registration system, it makes it a lot easier, which is nice. But part of making it easier means that they're getting a lot more registrations. So this year, for example, there are almost 781,000 registrations. And USCIS selected nearly 111,000. The reason they select above the 85,000 is because they're anticipating duplicate filings, cases that will be rejected, cases that will be withdrawn. And so they select above the 85,000 in anticipation of that. So, and that was really the case this year. They actually did a second round of selections because there were so many duplicates. And so actually they ended up accepting 188,400. So initially we thought the chances of selection this year were really low, but actually it was closer to what we've seen historically, which is about a 25% chance of selection. Now, this is further broken down into whether the person has an advanced U.S. degree. So there's two different lotteries that are run. The regular lottery is 65,000 and the advanced degree is 20,000. So those two together is how you get that 85,000. So if you have an advanced U.S. degree, let's say a master's degree, for example, or a PhD, then what happens is you get entered into that advanced degree lottery first. And if you receive one of those 20,000, great. If you don't receive one, then you go into the regular lottery of the 65,000, you have another chance of being selected. So people that have advanced U.S. degrees, like I said, master's or higher, actually have closer to like a 30 to a 35% chance of selection, whereas those who don't have an even lower chance of selection. Those who were selected in this year's lottery, their H-1Bs will become active on October 1st. As I said, that's the beginning of the government's fiscal year. The one other thing I wanted to mention here is with the H-1B, there's something called a labor condition application, or an LCA. And basically what that is it's the company being required to attest that they're going to make working conditions available to the worker that they're sponsoring from another country that is similar to conditions available to US workers. And one of those things is a salary requirement. So for each position and each geography, there's going to be sort of a minimum salary requirement that must be paid. So this a lot of times is something that new companies that haven't done this before come up against because they're not aware of what the government salary requirement is. So my advice is if you're looking to do this, make sure that the salary that's being offered to the employee meets the prevailing wage. And you can do that by checking with your attorney. Your attorney can look that up and let you know. H-1Bs are valid for an initial period of 3 years, followed by a 3-year extension, so 6 years total. And then one of the reasons the H-1B is such a valuable type of work permit is because it can actually be extended beyond that 6-year limit if the person starts the green card process. And that's not true of some of these other work statuses we're going to talk about. When you reach the limit, that's it, whether you've started the green card process or not. So that's why a lot of times somebody may come in a different status into the United States, but then the company really wants to get them into H-1B if they can, because it's anticipated their green card process might take several years. In terms of processing time, once all of the information is received, it takes about 2 to 3 weeks to prepare the case. And then once the government receives it, they're taking 6 to 12 months to approve those cases. You can file with premium processing. It requires an additional government fee of $2,500, so it's very expensive. But instead of having to wait, half a year to a year to get an approval, you can actually get an approval within a few weeks. And so if you have somebody who's already in an H-1B and you want to transfer them to your company, or if you're somebody with an H-1B and you want to transfer, it really makes sense to look at premium processing potentially to get that approval much faster. Somebody can actually transfer to a new company without the approval. They can do it based on a receipt, but a lot of times, if it's not a straightforward alignment in terms of the person's background of the new position, then premium processing may be something you want to look at. The other thing I'm going to talk about during this presentation is something called dual intent. So as we talked about, there's the non-immigrant intent and the immigrant intent. So if you come in on an H-1B or an F-1 to the United States and an H-1B, you're considered in a non-immigrant status. But with an H-1B, you can actually have the dual intent of becoming a lawful permanent resident or a green card holder because there's not a conflict there. There's not a conflict of intent. Whereas with other types of visas that we're going to talk about, there would be a conflict. So that means if you're here and you start the green card process, that shows the U.S. government that you're intending to be a permanent resident of the United States, and therefore the non-immigrant status you had will be nullified and go away. So that's just something to keep in mind. I'm going to talk about that several times during this presentation. The next work permit that comes up a lot is L1 for intercompany transferees. This is for people who work for a company outside of the United States for at least 1 year and then are looking to transfer to a U.S. office within the United States. So the company that you're transferring from has to have obviously an office outside of the United States and an office inside of the United States. When you transfer, you either transfer as an L1A, which is somebody who's a manager or executive of the company, or an L1B, which is somebody who has what they call specialized knowledge. And specialized knowledge really means that you have a unique skill set, or you've learned tools or processes within the company that are really valuable and not readily available in the United States. So then the company is justified in transferring someone here from another country because they have that unique skill set. A lot of times this question comes up where somebody says, well, I have a company in India, let's say, and I want to open an office in the United States. Can I do that? And the answer is yes, you can. You can transfer as an executive of the company. The issue to keep in mind, though, is when you transfer to the United States, that company in India needs to continue to be operational. You can't shutter that company. During the whole time that you have your L1A, that that foreign office or the Indian office in my example would have to remain open and operational. So you have to have both the U.S. operation and the company outside of the United States. They have to remain operational during the whole time. Somebody who's a manager is obviously somebody who manages people, but a lot of times somebody who's a frontline manager would not qualify. They really want to see somebody who manages other professionals, people with degrees, in holding professional positions within the company. If you don't manage people, you can still qualify as a manager or executive, but we just have to demonstrate that you would be considered a functional manager, meaning that you manage an essential function of the company, that there's a budget, that the operation that you manage within the company is critical to the overall success of the company, that sort of thing. Showing that you're a personnel manager is much easier than a functional manager, but I just want you to know that there's two different ways to qualify as a manager. In terms of duration, L1s are good for an initial period of 3 years, and then you can get a 2-year extension if you're L1B. If you're L1A, you can get two 2-year extensions. So L1A is good for up to 7 years. L1B is valid for up to 5 years. So in the scenario I referred to previously, where you have an office, and I'm using the example of India, this can be any country, but you have an office in India and you're the owner of the company, you want to come to the United States. What you would do, and you don't have to be the owner of the company, you could be anyone really within the company. But a lot of times the people we talk with are actually the owners of the company that want to then come to the United States. What we have to demonstrate, or what we would look to do for you, is what's called a new Office L. So you would show that you're establishing a new company in the United States, that it's incorporated, you have premises that are leased, where you're going to be able to be operational. And then we would file a new Office L1. And that initial filing is held to a fairly low level of scrutiny. Most of those applications are going to be approved, but they're only valid for 1 year. And really, at the end of that 1 year is when the difficulty potentially comes, because at that point, we have to show that the U.S. company is a viable operation. And this is where having a business plan can be really helpful to show that, this is what we're looking to do. These are the clients we're looking to have, or the work contracts that we're setting up. We're looking to staff and hire employees. One of the things that the government really likes to see is that what you're doing in the United States is going to create more jobs. So if we can show that in a business plan, and then at the extension phase, show that you've actually hired individuals, that the company is making money, revenues are coming in, and that there's plans for the future, then we can get an extension and you can stay here on more of a long-term basis. So that's a new Office L1. The next non-immigrant work permit I wanted to talk about here is the O1 Extraordinary Ability Visa. I'm going to describe some of the high-level things with you, and then I will walk through what the requirements actually are for an O1. So an O1 is for people who are considered to have extraordinary ability within the fields of science, education, business, and athletics. Basically, what we're showing is that the person has risen to the very top of their field, and they're nationally or internationally recognized for their work. They are among a small percentage of people who have made significant advancement or achievement within their field. There are 8 criteria that I mentioned earlier, and I will show you on the next slide. And the person needs to meet at least 3 of those. Obviously, meeting more is better, but at a minimum, they need to be able to meet 3. And typically, the people that we see that qualify have a PhD. And the reason is that the 8 criteria I'm going to show you are just, it's helpful if you're going for a PhD, because the things that you do within a PhD program lend themselves to meeting some of these 8 criteria. But that's not to say that a PhD is required. In fact, we find a lot of people within the business or even athletics fields that do not have a PhD, or a lot of times even a master's degree, but they have significant achievements. They've done a lot. They've either started companies, or they've held an important position at a publicly traded company. and had some significant accomplishments within their field that we can point to. So this here these are the 8 criteria that the government, that USCIS will look at when they review a case. And as I said, you need to meet at least 3, and more is better. The first is called original contributions. Patents are a great example of this because obviously in order to get a patent, you have to show that what you're doing does not currently exist. And so you're doing something new within your field. So patents are a great example of original contributions. The other thing we do for original contributions is we will have you get letters from others in the field who have either worked with you or know you by reputation to say in their letter that, yes, this person is making significant advancements. So there's kind of 2 ways, 2 primary ways that we work toward that. The next one is publications and citations. So if you're publishing your work, especially in journals with a high impact factor, and if your work is being cited at a high level, then that's very good evidence. A lot of people ask, well, how many publications do I need? There's not really a bright line rule. I would say typically we want to see at least 7 to 8. More is better. And if you have kind of on the lower end, then we would want to see a lot of citations to support those papers. We would want them to be in journals with a high impact. Articles written about your work by other people. So citations doesn't count for this. It's people who actually write, an article specifically about the work that you're doing. So it kind of goes to a higher level than just citations. Major awards that you've won in your field. We call this restricted membership. So if you're an engineer and you're in IEEE, that's not really strong evidence because essentially, most people who are engineers can apply and become part of IEEE. But now if you're within IEEE and you're, within one of the branches there and you're, say, on an editorial board or something like that, you hold a higher level position, that would be the kind of membership that we're talking about. Or if you've been invited to be a member of another organization that's like invitation only based on achievement, those are the types of memberships we're talking about. Previously employed by organizations with strong reputations. So if you're employed by a publicly traded company, for example, that's very good evidence. Commanding a high salary or remuneration. We have to show that your salary is at least 25% above sort of what the average salary is in your field and in your geography. And then judge or reviewer of the work of others. Peer reviews can be helpful, especially if you do a lot of them. But again, it's better if you're part of the selection committee or like on an editorial board. That's even better evidence of that final criterion. And if you can prove at least 3, then you may qualify for O1. O1 is a great visa because it's good for 3 years at a time. It's fairly easy to get in terms of processing times, whereas the H-1B was 6 to 12 months. The O1 is more like 1 to 2 months. It's much faster. And so you typically, unless you're in a real hurry, you don't need to add the premium processing fee, so you can save some money there. This is sort of a quasi-dual intent status. The government doesn't specifically specify that an O1 is a dual intent, but it sort of operates that way. And the nice thing about O1 is it mirrors very nicely with one of the options in the green card process that is a much faster option, and I'll explain that when we get to the green card discussion. But just suffice it to say that an O1, people who have an O1 can typically get through the green card process much faster. So it's a great, if you can qualify for it, it's a great status to have. The next one to talk about is one that not a lot of people look at for a number of reasons, and that's the J1. The J1 is really designed as a cultural exchange visa. So the United States has relationships with countries around the world, and the idea is that we want people to come here to the United States to get some sort of training or have a job, and then the skill set that they get, then they take that back to their home country because their home country needs that skill back in their home country. And so it's kind of designed as a cultural exchange visa. There's a whole bunch of different categories within J1. You can come as a nanny, you can come as a camp counselor, and a whole bunch of different options. The ones I'm going to focus on for our purposes are the intern and trainee classifications. Within the business context, these are the two that we typically see. Interns are people who are currently pursuing studies at a university outside of the United States or have graduated within the last 12 months. And the idea is they come to the United States to learn their trade, to work and get some on-the-job training, and then go to their home country, go back to their home country with that new skill set. Trainees are people that have a degree, at least a bachelor's degree, and 5 years of experience, and they come into the United States for some additional training. There is a 2-year home residency requirement that attaches. This is one of the reasons that people don't look at J1s as often, because depending on the skills that your home country needs, you may be restricted from staying in the United States after your J1 ends. And what they would want you to do is to return to your home country for at least 2 years to work there and use the skills that you gained here before you could then come back to the United States. Now, there's a way to get a waiver of that requirement. And in most cases, we're able to get that waiver. So if you feel like you want to stay in the United States after your J1 program, and there is a 2-year home residency requirement, we may be able to get you a waiver, and then you can remain in the United States without having to go home. You would need to change your status from J1 to another status like an H1B in order to remain in the United States. J1, unlike the H1B, L1, and O1 that I talked about, is a pure non-immigrant status. So this is not a dual intent status. So if you do want to apply for the green card, you would not be able to be in J1 status while you do that. As you move into the green card process, you would demonstrate your immigrant intent, and then the government would say, okay, well, you've changed your intent from non-immigrant to pure immigrant, therefore your J1 visa is nullified and it's no longer valid. And so you may be caught in limbo if you're trying to get a green card from a J1. So that's just something to keep in mind. The typical duration of a J1 is about 12, somewhere between 12 and 18 months. Extensions are possible, but again, the J1 is not intended to be a long-term solution. It's intended for people to be here for, a shorter period of time, return to their home country, or if you don't want to go to your home country, you may be able to stay in the United States unless there's a 2-year home residency requirement, but even if there is, we may be able to get a waiver. The next work permit is one, this I would say is kind of as close as you can get to a self-sponsor non-immigrant status. And the reason for this is this E2 is designed for investors, people who are wanting to come to the United States, invest their own money in an endeavor that they're either going to start themselves or they come here to purchase an existing business and then operate that business themselves. Or with partners. And so even though the status is really dependent on the success of that endeavor, I still say this is as close as you get to a self-sponsorship. Now, the first requirement here is that you have to be from a treaty country. And I'm going to show you guys something here on a different screen so you can see what I'm talking about and understand it. The first requirement is that you are from a country where there's an agreement with the United States that you can apply for an E2. So as you look at this page here, and you can just do a Google search for this. This is the State Department website. You can just do a search for E2 treaty countries, and it'll bring up this website. And what this shows you here is if your country is listed, let's say your country is Bangladesh, then you can see that Bangladesh qualifies for E2. It's on the list. If your country is not on this list, it means that you don't qualify, that you can't apply for an E2. So this is definitely something to look at before you commit to an E2 and start making an investment, because it may not be possible depending on your home country. Okay, so the next requirement, oops, The next requirement is that you're making an investment. And as I said earlier, this can either be a company that you're looking to start from scratch on your own, or this can be an existing business that you purchase. So your money can go toward the startup or an existing business. It must be what's called a substantial investment. And I'll show you on the next page what that means. These are just some of the terms to keep in mind. It cannot be marginal. It must be real and operational. And you need to own at least 50% of the company. So this is where you can have other partners and other people involved, but you need to own the majority of the company. It needs to be your company, really. And again, the E2, just like the J1, is a pure non-immigrant intent visa. So if you're on an E2, the intent is that you're going to do your business here. You can get extensions and stay while you're doing that, but then you're going to return to your home country. It is possible to do the green card process for someone who's an E2. It's a little bit more complicated, and I'll explain what I mean when we get into the green card discussion. So it's not totally precluded for E2s to apply for a green card, but because it's a pure non-immigrant intent status, it is a more difficult process. Okay, so here are some of the definitions. For investment, one of the main things is that the money has to be at risk, meaning a lot of times what people do is they create a company, they set up a bank account, and then they put money in the bank account and say, well, there's my investment, it's sitting in the bank. The government won't go for that. What they want to see is that the money has either been spent or is otherwise committed. Because the idea with an E2 here, like with most startup or new businesses, is that it has the ability to succeed or fail. There's some risk there. And so they want to see that the person is actually spending the money or has committed to spend that money. The investment needs to be substantial. One of the questions that always comes up is, well, how much do I need to invest? And that would be such an obvious thing for the government to tell us, well, it needs to be this amount. But unfortunately, this is one of those areas, and there's many of them within immigration, where we'd love to have a bright line rule, and we don't have one. And so what they really want to see is that you are spending enough money to be able to make this type of venture succeed. So in a way, it makes sense that they leave that definition open. I would say that typically we like to see investments of at least 40,000 US dollars. That amount or more, we tend to see a higher success rate. Now, you may be able to get away with $25,000 depending on the type of business that you're doing. But we would need to show that some of these other areas are really strong, like the marginal, real, and operational, and the business plan that you're doing has a really high chance of success. The other thing they want to see is that you're spending the money on things that they would expect to see a new company spend money on, like inventory, hiring employees, website, lease, those sorts of things that you would expect. In terms of marginal, they want to see that the business is going to have an impact in the United States. And as I said previously with the L1 or the new office L1, they want to see that you're going to be able to create jobs. And so if you have a business plan and you show that, within the first year, we're looking to hire 3 or 4 people. By year 2, we think we're going to have 10, that sort of thing, that is good evidence to the government to show that you have a plan to create jobs. That's something that they really want to see. In terms of real and operational, they want to see that the company is likely to succeed, that you have a way to create revenue. Either you already have customers or you have work orders coming in, things like that show that it's an endeavor that's likely to succeed. If you're buying an existing business, you want to be sure that that existing business is profitable. If it's a company that's losing money, you're going to have a hard time showing the real and operational piece of it unless you have a very good plan for showing how you're going to turn that around and make it a profitable endeavor. Okay, so the International Entrepreneur Rule there's some similarities to the E2 because it is a status for somebody to come into the United States as an investor. Or part of a new business that has investment involved. This is really sort of a carve-out rule that was created under the Obama administration to encourage more investment in the United States. So it's not something that we see all that often, but it's something that I want to make this group aware of because it might be something that applies. So the difference here is that you don't need to own more than 50% of the business. You can own anywhere above 10% of the business, and you can't own less than 10%. The other difference here is that you're not really investing your own money. You can, but that's not the main criterion. The main criterion is that you have an investor, typically an institutional investor that's looking to make this investment. And it needs to be what they call a qualified investor. So this is someone who, or an organization that has a track record of success with these types of investments. If you are working with a VC firm, venture capital, then you're likely to be able to show that this is a qualified investor because chances are they've done other types of investments. They can show that they've had success in the past. Where the difficulty comes in is where you have an individual investor, say an angel investor, for example, who does not have a long track record of investments. Maybe they've made a couple, but they haven't really been successful. We're going to have a hard time showing that they're a qualified investor. But if the individual has done a lot of these, then it's possible that an individual can qualify as well. Again, they're going to want to see that the company is going to be creating jobs. And then the one other thing to be aware of here is that unlike the E2, with the International Entrepreneur Rule, you're going to need to show that you're a major part of the operations of the company. You're not just a passive investor. So you're going to be, let's call it a C-suite executive within the company, the COO or the CTO or something like that. With that, we'll take a little break as we get ready to talk about green cards, and I'll just reiterate a couple of things. If you have questions, please feel free to put them in the chat. This presentation is designed to go for an hour, followed by a half hour of questions. So I will answer questions in the chat at the end of this presentation in the order they came in, up to a half hour. This presentation is being recorded, and we will make the presentation recording available to all attendees at the conclusion, and we will make the slide presentation available as well. So don't feel like you have to write all this down. You can have the slides and refer back to this at any time. Okay, let's talk about green cards. Within the employment-based realm, the green card process is typically a three-step process. There are 140,000 new immigrant visas available through the employment-based process every year. The vast majority come through either EB2 or EB3 categories. So that's the second preference category or the third preference category. If you do go through one of those categories, you're going to have this three-step process that I mentioned. The first step is PERM labor certification. The next step is I-140. You can see down kind of the left column of this page, I-140. And then the third step is I-485. The I-485 is the actual green card application. So if you're wondering at what point you can add family members to your green card process, and that's immediate family members, so spouses and children, you do that during the I-485 phase, that third step. So for those going through this process, the PERM labor certification is a little bit different. Most of the immigration benefits we apply for go through U.S. Citizenship and Immigration Services. The PERM labor certification process actually goes through the Department of Labor. And the reason that's meaningful is because the Department of Labor is set up differently than USCIS. Their role here is really to protect U.S. workers. And so the PERM process is designed for the company that's sponsoring you to show that they have tried to recruit U.S. workers for the position, but have been unable to do so. So what the company needs to do is to post the job opening in 6 different locations. There are 3 that are required, and the 3 that are required are Sunday newspaper ads, which I think is hilarious because the government still thinks people look at Sunday newspapers to find a job, which we know nobody does. But anyway, that's still a requirement. The next one is posting the job with a state workforce agency, and the third is posting it at the job site, wherever the job opening is. Then there are many other possible forms of recruitment that the company can choose, at least 3. These can be things like posting it on the company website, posting it within trade journals, posting it within a local newspaper, job fairs, employee referral programs. There's a whole bunch of options that are available there. And they need to choose at least 3 of those. Once they do that, then they need to collect resumes for a period of at least 30 days and then demonstrate that none of those resumes were from a qualified U.S. worker. If they were, or if they do get a resume from a qualified U.S. worker, the company can do one of 2 things. They can either decide to stop the perm labor certification and put it on hold for at least 6 months, or they can hire that U.S. worker and then continue with the perm labor certification process as well. The one other thing to keep in mind is whether somebody is the second or third preference category depends on their background. Somebody who has an advanced degree, like a master's degree or higher, and it does not need to be from the United States, it can be from their home country. But the one thing we need to show is if it is from their home country and it's a master's degree, let's say, we need to do an education equivalency to show that it's equivalent to U.S. master's degree. Some countries have different requirements in terms of the credits that need to be taken. And so we need to show that in your home country, the work that you did as a student was equivalent to the work that you would have done in the United States. So again, it doesn't need to be a U.S. degree, but it doesn't at least need to be an equivalent. So if you have an advanced degree, you can qualify for the second preference category. Or if you have a bachelor's degree followed by at least 5 years of experience, you can qualify for the second preference category. If you don't have an advanced degree and 5 years of experience, then your case falls under the third preference category. I'm going to share another screen with you here so that you can see why this makes a difference. What I'm showing you here is the monthly visa bulletin. So if you see this chart here, in the far left column where it says first, second, third, those are the preference categories that we primarily deal with, first, second, and third. I was talking about second and third, and that's where you have the perm labor certification process. Now, if you look across the top, you'll see countries listed. You'll see China, India, Mexico, Philippines. If you're from one of those countries, then that's your column. If you're not from one of those countries, then you go to that first, or actually say second column that says all chargeability areas except those listed. And then if you go down, you can see what your priority date is. So let's take a look here at China, actually. So if you look at the second preference category for China, you'll see that it has an effective date of January 1st, 2020. In the third preference category, it's September 1st, 2020. So typically, being in the second preference category is an advantage because historically fewer people have qualified. But you see something interesting here in China, where the third preference category is actually better, because what these dates mean is that you have to have started the green card process. So if you're going through the perm process, it's the date your perm labor certification is filed. That's your date, and that marks your place in line. So if you're from China and you file today, let's say your perm labor certification, and you're in the third preference category, then you're looking at roughly 3 years before you're going to have a current priority date, which means that you have to wait to file that third step in the green card process, the I-45, until your priority date becomes current. And so you want to be in a category that is more advantageous. So some people might say, well, shouldn't I just, even though I qualify for the second preference category, shouldn't I just file under the third because the dates look better? My answer to that is they look better right now, but this visa bulletin comes out every month and the dates move. My advice is to apply for the highest preference category you can, because if it gets to the point where the third preference category is better and that date would be valid for you, you can actually downgrade from the second preference category to the third preference category. So you can take advantage of those better dates within the third preference category if you're in the second preference category. But if you're in the third preference category, you can't upgrade to the second preference category. The only way you could do that is you would have to start over, file a new perm labor certification and a new I-140, which is expensive and time consuming. So again, my advice is always to apply for the higher preference category, highest preference category that's available to you. Okay, the second step of the green card process is the I-140. So once the perm is approved, the perm labor certification, you file the I-140 with the USCIS, and that I-140 is the immigrant petition. So if you're in one of those statuses where I said it's not a dual intent status, if you start the green card process, your J1 is going to go away, or your TN or whatever status you're in is going to go away. It's at the I-140 stage that happens. So the reason you can move toward a green card potentially is if you're in a category that has a current priority date or a priority date that will likely become current by the time we file the I-140, then you may be able to move from your pure non-immigrant intent status into the green card process. So let's say, for example, you're from a country where there's only 1 year of retrogression. So if we file, let's say you're an E2, you're somebody in an E2 status. So if we file the perm labor certification, perm right now is taking about 12 to 18 months. So by the time that application is filed and gets an approval, chances are your priority date may become current. So then once that happens, we would look at the I-140 and say, okay, do we want to file it now? Because once we do that, that E2 is going to go away, or J1 or whatever it is going to go away. If not, we may want to wait a little bit for the priority date to become current, and then we can file the I-140, we can file the I-485 at the same time. And then what will happen is when we file that I-485, you can also file for work authorization, and it takes a few months. But once that work authorization comes, then it doesn't matter that your J1 or your E2 or your TN or whatever status it is goes away, because then you can continue working in the United States based on your pending green card process. So that's why I say, even if you're in a pure non-immigrant intent status, it's possible, depending on the country you're from and the preference category you're in, that you may be able to proceed with the green card process anyway. So that's just something to keep in mind. So here's that visa bulletin again, put into a slide. As I said, so one of the questions that comes up is, why is there such a long wait for people from India, let's say, in the second or third preference categories? So that 140,000 new immigrant visas that are available every year, there's a law right now on the books that says no country can exceed 7% of those 140,000. If they do, then they're going to have to wait for the next year. Next year's 140,000, and then we'll let them apply next year. And so where you have countries that exceed that 7%, and we see that mostly in India and in China, then a line starts to form, and that's what they call retrogression. So you might hear somebody say, well, your priority date is retrogressed. And what they mean is that you have a wait period before an immigrant visa number is available to you. Your priority date is very important, and it's something to keep track of, because your priority date is the date you can compare to the visa bulletin every month to see how much longer you have to wait. For example, if you're somebody that filed 5 years ago, and you're in the second preference category for China, then you're eligible now to apply for a green card. But if it was 3 years ago, then you may still, it looks like, according to this visa bulletin, you may still have a year to wait before you have a current visa number. The categories that have a C, I should mention this, the categories that list a C means current, so there's no wait there. But I was talking earlier about the second preference category for all other countries. So let's say you're from Germany in the second preference category, your wait there, according to this current visa bulletin, is a little over a year. And so by the time you go through the perm labor certification process, it's possible that your priority date may be current at that time or very close to current, in which case you could proceed with not only the I-140, but the I-485 as well. So the only petition that is held up by this is that I-485. Anybody can file the perm, anybody can file an I-140, but in order to file the I-485, that third step, you have to have a current priority date. Okay, so I'm going to talk about a couple of self-sponsorship options within the green card process. So most green card process, people that go through the green card process are sponsored by their employer, and their employer pays for it, and they're kind of tied to that employer because the employer applied for their green card process. If you self-sponsor, meaning you file for yourself, you're not using a company, then you're not tied to any particular company once your green card process is underway. So the first of these is called the National Interest Waiver. Basically, what we're showing is that the work that you're doing is broadly within the national interest of the United States. And so the ways that we do that are with these 4 areas that are listed here on this slide and underlined. The first is substantial merit. Again, we see this create jobs requirement. This is something the government wants to see in order to qualify for national interest waiver, is that the work you're doing is likely to create jobs within the United States. The fields that we commonly see qualifying for national interest waiver are fields of medical research, homeland security is really important right now, renewable energy, education, and then more recently is the financial system. As we've seen banks being distressed and some issues with the economy, people who are in the financial field are more likely to find success within the national interest waiver. So some of this stuff is always important. Medical research is always important. Other things become more important depending on what we're going through. Homeland security, if we're dealing with some sort of a situation where it feels like the United States is potentially, there are potential threats, and this can be physical threats or this can be cyber attacks as well. If you're involved in homeland security during that period of time, then a national interest waiver application is more likely to be approved for you. We have to show, again, that it's in the national interest. And so, I mentioned that these fields. So if you're in the medical field and your work is to help cure cancer, obviously that's in the national interest of the United States because, fewer people having cancer and getting sick is a great thing, but also it creates less stress on the overall economy to have people who are healthy. So you make these legal arguments to show why the work is within the national interest of the United States. The next one is that you're well positioned to be able to carry out that work, that if you're starting a new business, that you have investors involved in that business, or maybe you have a patent in your name, and so you're going to be able to do work within that patent, that you have contracts and even endorsement letters from other people saying that this person is going to be able to carry out this work. And then on balance, that this is in the second preference category. And if you'll remember, typically people in the second preference category have to file a perm labor certification. For national interest waiver, you actually get to skip the perm labor certification. And so the fourth criterion is to show why it's in the national interest of the United States to skip that perm step. Because remember, the perm is the Department of Labor's check to make sure that U.S. workers are not being displaced. And so what we have to show here is that, well, the national interest of the United States is so involved here that we shouldn't even have to do that check to make sure U.S. workers being displaced, because it doesn't matter. This work is important enough that we can skip that perm labor certification. The next self-sponsor option is EB1A, and you'll probably recognize this from our discussion on O1. It's exactly the same list of 8 criteria. So that's why I said if you qualify for an O1, it's a really great green card process for you because it streamlines your ability to get into the first preference category, where you get to skip the perm labor certification. And the priority dates, as you'll remember from the visa bulletin, for the first preference category are much better than priority dates within the second or third preference category. So I won't spend a lot of time on this because we already covered this with O1, but it's essentially the same sort of thing. Extraordinary ability within the sciences, education, business, or athletics. A lot of times we see people with PhDs if they're in the science or education fields or even technology. Those within business or athletics often don't have a PhD, so it's not required, but we just have to show that you've had some success within your industry. I'm going to spend a few minutes on these final, I think there's 3 slides left here. These are sort of reference slides. And again, these slides will be made available to you. So don't feel like you need to screenshot or write this down or anything like that. You'll have this for reference. But the question on how long it takes, I've got here listed how long each process takes. And then where premium processing is available, I've listed a PP in green. Where premium processing is not available, that PP is in red. So most of these allow for premium processing. The ones that don't, and as you may remember, premium processing requires that additional $2,500 government fee in order to get an approval within a matter of weeks instead of months in most cases. So the one that's really too bad right now is that I-485, that the third step in the green card process. It's currently taking 1.5 to 2 years, and there is no premium processing available. So that's why even for people that have current priority dates, the green card process is likely going to take 2 to 3 years from start to finish. And people from India in one of those second or third preference category, it'll be much longer. So that's why I said at the beginning of the presentation, typically we want to get people into the H-1B. So you may come on like an L1 into the United States initially, or maybe a TN. And then we want to get those individuals moved into H-1B because the H-1B can be extended indefinitely as we get into the green card process. So once the I-140 is approved, that second step in the green card process, then the person can extend their H-1B 3 years at a time, indefinitely really, until their priority date becomes current. Then they can file that third step of the green card process and get their green card. So if you are from one of the countries that has a long wait, don't despair. We can get you into an H-1B, you can work, and you even have flexibility within your job. You can move, you can transfer to a new company, you can take promotions. The one restriction is you can't do sort of a lateral change where, like if you have a degree in engineering and you decide you want to go into human resources, that's the kind of move you would be restricted from making. But for the most part, people can advance their careers and things like that while they're waiting for their priority date. In terms of cost, this is kind of a range that you'll see for most of these processes I've talked about. The range comes up because there's a few factors like how much the law firm charges, whether you file with premium processing, whether you're including a spouse or even children in your process, and there's other factors like business plans, if you're going to pay for a business plan. So there's a range there, but this gives you a sense of what the cost looks like for each of these. The next slide here is how long they're valid. As I said, with the H-1B, 6 years, but you can extend indefinitely as long as you start the green card process. I also have listed here whether it's a dual intent status, meaning that you can be a non-immigrant and an intending immigrant at the same time, and then whether extensions are available and how many extensions are available. Again, you'll get these slides, so don't worry about memorizing all this. And with that, I will move to the chat now and answer questions that came in for everybody. And I will do this for the next half hour. I will answer questions here. I'm going to start at the beginning. Okay, this first question says, to apply for a work permit in Canada for a Canadian company, should we apply for H-1B? How is it different if I apply for a Canadian citizen versus an Indian who is in India? So the main difference for people who are Canadians is that people from Canada do not require a US visa. They Canadians are visa exempt. So whereas most people need to apply in their home country for a visa stamp and then use that visa stamp to enter the United States, Canadians can actually make their applications at the port of entry. And so they don't need to go to a US consular post in Canada to get a visa. So that's the main difference. The other difference is people from Canada qualify for a specialized visa called a TN visa. It stands for Trade NAFTA. And actually, the name changed. I think it's now USMCA. But anyway, the visa is still called a TN visa. And it's available to people from Canada and also people from Mexico. So my advice is people who are Canadian can typically come in on a TN visa. It's a very straightforward type of work permit. And then if necessary, we could move you to an H-1B. But typically, people from Canada have pretty good priority date, have a decent priority date, and may not need to do that transition to H-1B. So you may be able to move from your TN directly into the green card process. Okay, the next question says, my company is going to be laying off 95% of my organization soon due to an acquisition. I'm getting multiple contractor roles, but I'm also considering an E2 visa, but then I would need credible plans to hire people. What is easier to transition to? Currently, the perm part of the H-1B process. First of all, sorry about this. I know this is something that's happening everywhere, these layoffs, especially within technology. We've seen a lot of this. So if you are an H-1B, my advice would be to use your H-1B to move to a new company. It's a fairly straightforward process to transfer your H-1B to a new company. You could do an E2, and if you have money to invest and you have a good startup plan, you could look at doing that as well. But often I would say that it's easier to keep your H-1B, move to a new company, and then once things are more settled and you can focus on the startup endeavor that you have, then you can maybe move to an E2 at that point. In terms of your green card process, if you're in the middle of perm when this happens, you're going to need your new company that you transfer your H-1B to is going to need to start a new perm labor certification for you. So that's kind of bad news there. But that's another advantage of the H-1B. I would say if you transfer your H-1B to a new company, then they're likely to get your green card process going again. Whereas if you go to E2, it's possible that you can do it, move to the green card process, but it has those restrictions, like I said before, whereas H-1B is a dual intent status. The next question says, I'm an international student under F1 visa, and I'm currently doing market research on my startup, and I want to establish it. Could I establish my own startup and building a business in the US? And what else happened? Yeah, so moving from when you're a student in an F1 status, it's anticipated that your primary objective is going to be your education. And so the timing of this is important to consider because if you're in the middle of a degree program and then you start doing work on the side, that work, you may run afoul of immigration laws by doing that work on the side. So what you would want to do is be careful. Either you would need to make a seamless transition from being an F1 student to the E2, or you would need to wait until you finish your F1 program. And then while you're in that period after your graduation, you can apply for work authorization called optional practical training. And then during that transition period, you can apply for an E2. So again, we just want to be, you would want to be a little bit careful on the timing here to make sure you don't violate your F1 status. Okay, how many citations typically are good? I'm guessing this question is in relation to the O1 discussion or the EB1A discussion. That's a tough question because what we would be looking at is the whole body of work. If you have 10 articles that you've published and each one has, 50 to 100 citations, that's really great. If some of them have 12, to 15, and then others have 0, and then maybe you have a couple that have like 200, That can be good too, because you have a couple of really strong articles. So we kind of just have to look at the whole thing, the big picture of the entire case. It's hard to say just how many citations, what the bright line rule on that is. I'm on a STEM OPT visa that lasts for 12 months, and I'm in the process of incorporating my startup company, and it was recommended that I apply for Investor Entrepreneur Parole visa. When would you recommend starting a visa application when compared to the company's incorporation timeline? And if there are any specific materials that help assume the visa success, how long does this process usually take? Its approximate cost. Yeah, so this is definitely something that you could do. Again, as I said on the previous question where somebody was wanting to look at an E2, it'd be the same kind of thing where you would want to be careful about the transition. But it sounds like you graduated and you're in your OPT period. So this is a good time to make that transition to the International Entrepreneur Parole. There is some risk involved because we need, all of those things that I showed before, where we need to show that it's a qualified investor, that the investment amount is sufficient, and that it's an endeavor that's going to create jobs and all those sorts of things. So I would say that you want to be a little bit careful about that before you make that leap. But it sounds like you're actually in a good position right now to be able to do that in terms of timing. Question says, does all of the criteria in the definitions page for E2 need to be met for an application to be approved? Yes, that's a good question. So all of those criteria, I said you have to meet all of them, not just a couple. So those are all requirements. For International Entrepreneurial Visa, does Kickstart crowdfunding qualify for investor dollar? Yes, it can. And actually, this is a question I haven't really considered before because, really you have within a Kickstarter fund, you would have a lot of different investors, even though Kickstarter is a really well-known entity. They're not exactly the investor. They're just sort of facilitating that investment. So I might have to think about this one a little bit before I give you a definitive answer, but it does make me a little bit uncomfortable that type of investment might not qualify. But that's a good question. I'd have to think about that one a little bit. Does the work visa cover the spouse and children? So yeah, so for all of those non-immigrant visas that we went through, so the H-1B, the J-1, I've talked about TN, O-1, you can, for any one of those, you can apply for spouse and children as dependents to come to the United States as well. Most of them do not allow for spouses to work. There are some like H-1B where a spouse that would come in an H-4 status can apply for work authorization. The same goes for L-1. The spouse would come in L-2 and would be able to work. But for TN, for example, or O-1 or J-1, a spouse coming in would not be able to work. So that's something to be aware of, is if you're going to do one of these and your spouse wants to work in the United States, he or she would either need to verify that they could get work status as your dependent, or if not, that they would need to apply for their own work authorization. Next question says, I overstayed my visa in the US 2 years beyond 1 year, and now the 10-year bar applies to me. Can any of these visas overcome the bar with a waiver of grounds of inadmissibility? This is a question that's a very personal question because there are a lot of nuance that go into these types of situations. So I would say it's kind of hard to answer that question generally. I would say no. These visa categories would not help you overcome that. You would need to address that directly. And we would obviously need to know your circumstances to know how to address that. But you would need to get that waiver first in order to be able to benefit from one of these other types of visas. I have a company in Australia, more than a year old. I want to establish my business in the US as well. What are the best visa options available for an Australian citizen? I think E2 visa. And how long does it take to get the visa? Which is the best location to open the company in the US? Okay, so this is one status I didn't talk about because it only applies to Australians, but there is an E3 visa. So not E2, it's E3, that's available only to Australians. So that could be an option for you. The other thing to consider would be that new Office L. So this is one where you have a company in Australia, you would set up a new company in the United States, and then because you've worked for the Australian company for at least a year, you could then transfer to the United States with a new Office L. The issue often, as I said before, if this is your company, is that when you leave Australia, you would need that Australian company to continue to be operational for the full duration of the L1 visa. So if your plan is to come and then close that Australian office, then an E3 would probably be a better option for you. But there are some restrictions there as well. So I would say if this is something that you're looking at doing, we would need to get into the specifics a little bit to see what the best option would be for you. It seems like there's a couple of options potentially, but both have potential restrictions as well. I would need to know a little bit more. Oh, and in terms of where in the United States, it doesn't really matter. A lot of companies will incorporate in Delaware because they have good incorporation rules. So Delaware, but then you can incorporate there and then you can operate the business in whatever state you want to be in. Then it says also, what are the visa options available to Australian doctors to work in the US? Again, that E3 I think is probably going to be your best bet. The nice thing about the E3 is it operates very similarly to an H-1B, but it doesn't have that annual limit, so you can apply at any time for an E3. Next question says, can I file an I-485 before my I-140 gets approved? The answer to that is yes, as long as you have a current priority date. So you would need to figure out what your priority date is and then look at the current visa bulletin and see if your priority date is current. If it is, then yes, you could file the I-485 even if your I-140 is not approved yet. Next question says, does E2 visa applicants already had hired people to qualify for this visa option or just show intent of employment? At the initial E2 filing, you can just show the intent to hire. So that's where having a business plan is very helpful to show that, again, within year one, we're going to hire 3 to 4 people in these specific positions. In year 2, we're going to be up to 10 employees. So you don't have to have them already hired. You have to have a plan to hire. If you're acquiring an existing business, then you would want that existing business to have at least 3 or 4 employees already. Next question says, would more recent fields like AI or Gen AI be part of the national interest waiver, since it is in the U.S. interest to build the talent pool and make sure they come out on top when it comes to AI jobs and technology itself, i.e. generative and interactive AI, as well as the future potential of AGI. I have to be honest, I don't know all of these AI terms. I understood some of it. And then it says AI isn't a recent field, but generative AI and LLM related technologies is. I would say yes to this. And I think a lot of it would come down to if you're focusing it in a specific field, what field that would be. If it's just sort of, kind of like open source and it could be available to a lot of different industries, again, I think there's a strong legal argument to be made that is in the national interest of the United States, particularly if you're looking at things like, how do we do this responsibly? How do we roll it out to make sure that, there are rules and parameters around this so it doesn't sort of, get out of control. I mean, so we would want to get into the nuances specifically of what you're doing. But I think the short answer is yes. I think AI is definitely an area that we could prove national interest. If I name myself as the founder of a C Corp and I am able to sponsor my own employment as an H-1B first while trying to get E2 or International Entrepreneur Parole. So there is something to be aware of. If you own your own company, it is difficult to apply for an H-1B and really even to go through the green card process if you have to go through perm. And the reason is what the government wants to see is, so you can do it, but what the government would want to see is that you have the ability to be fired from your job, that you're not, because H-1B is not considered a self-sponsor work status. It's where an employer sponsors an employee. So if you are, let's say, the CEO of your own company and you want to do an H-1B, the way to do it is you have to show that there's a board of directors that has the ability to fire you if you're not doing a good job, if you're not meeting metrics and things like that. So you can do an H-1B. It's just a little bit difficult to get around some of those to demonstrate employer-employee relationship. So yes, the answer is yes, you can do it. You just need to be cautious in making sure that you do it the right way. What do you mean by quasi-dual intent status for O1? So with these non-immigrant statuses, again, the overarching idea is that you're not here on a long-term basis. You shouldn't really be a non-immigrant while also intending to immigrate to the United States. There was a carve-out specifically made for H-1B and L1, saying that we're going to allow people in those statuses to have dual intent. Now, O1 is not specifically called out in that carve-out, but the way that it works and the way that it operates, you really can be in an O1 and start a green card process. And the reason for that is you don't need to go through the perm labor certification process. You skip straight to that first preference category where you file the I-140, and then if you have a current priority date, you file the I-485 at the same time. So that's why I call it quasi, because it's not specifically called out in the law as a dual intent status, but it sort of operates the same way. The next question says, yes, I want to transfer my H-1B to a new company, but many are reluctant to sponsor and pay for H-1B. Yeah, I know. It is a hard time. And a lot of people are getting laid off within the technology sector. I would say this started, at the beginning of the year, maybe even before that, and then it's been harder to find new jobs. So I understand that that's difficult right now. I think looking at other options is a good idea. These sort of self-sponsor options can be a good opportunity at this point. But typically those processes take a while to get all the documentation prepared, to get the case filed. And you may find yourself in a situation where you don't have work authorization, or you fall out of work authorization because you're preparing the new application. Whereas with an H-1B, if you can find a new employer, that transfer process, you're likely to avoid gaps in work authorization. So I'd like to take advantage of the International Entrepreneur Rule with my new company if I can secure a VC investment. As a backup plan, do you recommend applying for H-1B through as many companies as possible next year? This way, if selected, I could transfer the H-1B to my own company in the US sometime later. I applied for the H-1B through one company this year and wasn't selected. Yeah, so this is one of the things that happened this year is there were a lot of duplicates, and that's perfectly fine to do that. If you can find, let's say, 4 companies and they all want to try to get an H-1B for you, you can have all 4 companies apply. The area you need to be careful of is not filing what's considered a duplicate. Well, I just said duplicates are okay, but what I'm meaning is that you have one company filing one case for you. What you want to avoid is having one company file multiple cases for you. So where people ran into trouble this year is where there's a company that has a lot of sister companies, let's say, or affiliated entities. And then they had, the main company apply for the H-1B, and then they had all these affiliates apply for the H-1B as well. Well, really, that's considered part of the same organization. And if USCIS discovers that, which they've become really good at, so I wouldn't recommend doing it, they'll actually disqualify all of those applications, and then you'll be taken out of that lottery completely. So you just want to be sure if you do this, that you have independent companies that are not affiliated with each other filing those applications for you. And then, yes, it does increase your chances of being successful. Okay, is seeking employment, applying to U.S. jobs, an allowed activity while in the U.S. under a B-2 visa from Canada? Yes, if you're in the United States on a B-2, the restriction is that you can't do work while you're here, but looking for a job is a permitted activity, so that's fine. What work authorization is needed for a Canadian citizen to work remotely from Canada for a U.S. company? If you're a Canadian citizen in Canada working for a U.S. company, there's really nothing you need to do. You need a visa really to enter the United States and work in the United States. So if you're in your home country and you're doing remote work for a US company, that's totally fine. You don't need a work permit for that. Next question says, I'm an EU citizen traveling for medical reasons with an ESTA tourist visa. What should I do if I need to extend my stay for continuous medical treatment? And is there a way to work or study in the meantime? So if you're here on ESTA and you need to extend, you'll need to file a form called an I-539 and request an extension. And well, it's kind of an extension, but really what you're applying for is a different status. You'd be applying for a tourist B2 status on that I-539, explaining that you have, this medical emergency and it requires you to stay for a longer period of time. A lot of times what happens is those applications take many months to be approved. And so it's possible that while it's pending, the time may come for you to go back to your home country, and that's fine. You can just withdraw that application at the time you leave. But by filing it, basically you're securing your ability to remain in the United States, as long as you file it before your ESTA status expires. And there's there's not a way within that status to be able to work or study, but you could always file a change of status. So if you decided you wanted to enroll at a university and you're accepted within that university, you can ask them to sponsor you for an F1 visa, and you could begin studying as an F1 student. So that would be a change of status application. Okay, you express for F1 visa that the time is important. I'm an MBA student and I'm in the middle of the first year and 1.5 years left from my education, but due to the core of my startup that is relevant to education and ed tech, is not an opportunity to apply currently for establishing as a budding entrepreneur. So these questions that are very specific to your circumstances are tough to answer in this sort of a format. I would need to know sort of more context, I guess, and I appreciate the additional context in this question. I would say that it's yes. The answer is yes. It's possible, but I don't want this to be construed as me giving you specific advice on that, because I don't really know the full extent of your circumstances. So I would say sort of generically, yes, you could do it. But I'm not necessarily advising you to do that. I would need to know more. If my E2 or EB2, EB3 sponsored by my employer will become current for Form B to apply for EAD card in half a year, do I need to wait for 180 days to start work for my startup according to AS2? If yes, would switching to O1A provide a faster path to start working on my startup? Yeah, so in O1A, the process can go very quickly. Typically, the longest delay we see is actually in gathering the documents themselves. As I mentioned, we like to get letters from other people in the field, and sometimes that takes a while. We can help you put those letters together. We have templates, or we can even help you write them. And then you can send those out and get those signed. So that takes a little while, but once we file, the time that it takes USCIS to actually approve the case is around 1 month. And so it's a pretty fast process to be able to get an O1. So I would say that's definitely something to think about. Obviously, there's a cost of it, and the cost is probably going to be about $5,000 to $6,000. So I mean, that's a significant expense and something to definitely weigh in your decision. Are there options for H4 holders, Canadian, to legally work in the US without their spouses necessarily having an I-140 and with their own work visa? Yes. So if you are Canadian, then I would say a TN visa is a great option for you to look at. For an H4 spouse, in order to apply for an EAD work card, you do need to wait for that I-140 to be approved. So if that's going to be a little while, then yes, you would probably want to look at a TN. The one thing I should say about TN visas is, unlike an H-1B, where it's a very broad category where, basically any specialty occupation can qualify, for TN, there are specific categories that are available. So like if you're an engineer, for example, that's a category that's authorized. You know, a lot of finance, a lot of medical, but not any job would qualify for a TN. So you'd have to be sure that it's on the list of approved TN categories. Okay, what is the recommended visa for someone who has a PhD in AI? What is the visa for postdoc in the US? How is different from H-1B, assuming it is different? So there's not a specific visa for someone with a PhD. As I've said before, typically people that apply for O1s often have a PhD. And that's just because by virtue of going through the PhD program, you're doing things like publishing your articles, maybe doing peer review work, you may be getting a patent. So there's those types of activities that often lend themselves to an O1. So that would definitely be something to look at. But yes, an H-1B would be a possibility as well. And if you happen to be from one of these other countries, like Australia that has the E3 or Canada, Mexico that has a TN, then that might be an option as well. All right, we're getting close to the end here, and we have about 5 minutes left. Let's see if I can get through the rest of these. Can someone on DACA who has worked 5 years in the U.S. company apply for H-1B visa, or whether options are available? Unfortunately, DACA is sort of it's a category where it's great. I mean, it's nice that they're deferring any action, but unfortunately, you're sort of stuck as someone in the DACA category, and so extending your EAD right now is the best option for you, not moving to H-1B. So hopefully there will be legislation in the future. So these poor people that are, you poor people that are stuck in this category, you don't have to just file extensions for the rest of your lives. But yeah, for now, that's the best thing to do, is just to continue to file those EAD extensions. Is there any difference from visa perspective, working green card, between working in industry and working in academia? I don't think so. I'd have to think about that for a little bit, but typically it's the same visa options that are available to somebody who's in business versus academics. What if startup fails? Parole will be interrupted. So I assume this is for the International Entrepreneur Rule. Yeah, and so it's actually not a status per se. They call it a parole because it's basically sort of a temporary authorization. It's sort of like DACA, where you're authorized to remain in the United States and work during that time period as long as conditions remain the same. So yes, if the business fails, then that parole would be interrupted and you would need to return to your home country. All right, this will be the last question I answer, and then we will sign off. And I appreciate everybody joining. We will make this recording available. You will get the slides. And again, I encourage you to follow us on LinkedIn, and then feel free to reach out to me with anything additional. Again, thank you for joining. It says, can you find a few companies sponsoring your H-1B at the same time? Is there any bad effect? Okay, so I answered this question previously. The main thing is you need to be sure that the companies are distinct entities, that they're not affiliated. But yes, you can do that. You can have multiple companies file for your H-1B. It does increase your chances of being selected in the lottery. I don't know if USCIS is going to change that down the road, because this year a lot of people did that, and that's why we had so many applications. And I imagine this coming year, that's a strategy a lot more people are going to do. So we could see the total registrations go up. And again, that might be something that USCIS looks at in the future. But for now, if you have multiple companies apply for you, then you do increase your chances in the lottery. Thanks, everybody. See you next time.